Hey everybody, you're back with Jim Hacking and Mackenzie Simmons of the Hacking Law Practice LLC. Mackenzie always loyally wears her blue hoodie when we do one of our Ask Me Anythings, even when it's 95 degrees outside. It's pretty hot here in St. Louis. There's our buddy Will, and he's already got his question up there. We'll start doing questions in a little bit. Everybody, go ahead. Let us know where you are and what you got going on. Oh yeah, everybody's got their questions ready. Will's in New York City, where the girls are pretty. All right, let's see. All right, we'll let people register or sign in on the chat. If you could, leave us on the chat a note about where you are watching from, and then we'll start taking questions here in a minute. Mackenzie's going to go through the questions one by one and feed them to me. Before we get started, I guess I'll go ahead and give you a brief update of the things that we're seeing. USCIS, I still have my braces, see? So I still have funny speech things. And over here, it's sort of shredded, the rubber band shredded. So it's sort of, anyway. You guys don't care about that. USCIS reopened on Thursday last week, and we've started getting interview notices and oath ceremonies. We had a client naturalized today, actually, down in Memphis, someone that we had filed a lawsuit for. So, a lot of people ask us about the lawsuits. Well, maybe I should wait, blah, blah, blah. I said, well, if you file your lawsuit now, you'll be first in line. So one of our embassy overseas cases in Pakistan got approved today. So I think that people are on the government side itching to get going. So, it's going to be a new world at USCIS as far as having to wear masks and stuff at interviews. That's going to be sort of a bummer, probably mostly for the officers who have to wear them all day. So sort of that's one thing. You guys can probably see my San Diego hat. That's all with a wink and a nod to my desire to open an office of the Hacking Law Practice in San Diego. My son Ismail will be a freshman at San Diego State University in the fall. He just got word yesterday. I probably didn't tell you this, Mackenzie. He just got word that out-of-state freshmen are going to have the #1 priority for the dorm. So he pretty much has a dorm spot. So he's excited about that. And if I have an office out there, I'll have someone to go visit, and vice versa. If I want to go visit him, I can check on our office. So that's a long-term project. Whenever I bring it up, my wife, who is my law partner and my life partner, gets all upset and anxious about it. So, but that's the goal. And she was the one who told me to go to San Diego to visit. And I went up there. We got off the plane. And have you been to the airport in San Diego, Mackenzie?
Yes, last for Cleo.
Oh yeah, right. So you go up you come in. It's a pretty small airport actually. You get your luggage, and then you go up that escalator, and then you go across that bridge, and then you go down to the tram to get the rides. When I was on that bridge, I was like, "Oh, this is the place. I really like it here." So the next day, I got up early in the morning while she was asleep, and I had my phone, and I made a video that said, "Hey everybody, just want to let you know I got a big announcement. We're going to be opening up an office in San Diego." I did it, and I filmed it outside the USCIS office in San Diego. And by the time my wife woke up, she had received like 60 messages from people. "Hey, I heard you're moving to San Diego." She's like, "What is this crap?" She was all mad. So, but anyway, San Diego's a hard place to beat. I checked today; it's about 75 and sunny there, which it is most days. All right, so Mackenzie, I am going to have a sip of water, and then we'll go ahead with our questions.
All right. Will asks, can you submit the I-130 and the I-864 at the same time? Is there a way to do this?
Will, I believe your case is overseas, so you wouldn't submit the I-864 with the I-130. On an overseas case, you file the I-130 to get it approved, and then later on you're going to submit all the financial stuff when you get to the National Visa Center. If it's a USCIS case and the foreign national is going to seek adjustment in the United States, then you would go ahead and file the, on an initial spouse-based green card, you're going to file the I-130, which is the petition for an alien relative, the I-485, which is a application for the foreign national to adjust their status to that of lawful permanent resident. An I-130A, which is the biographic information for that foreign national. The I-765, which is the employment authorization. The I-131, which is the travel document. The I-864, which is the affidavit of support, which is the form that Will asked about. That's where the U.S. citizen is promising to the government that they're not going to get government benefits, that the foreign national is not going to get government benefits, and if they do, that the U.S. citizen will pay them back. And then the new form that we have to do, which is such a pain in the butt, is the I-944, which is the petition of self-sufficiency, which is where they actually inquire into the ability of the U.S. citizen to support themselves when they come to the United States. And there's like a 6 or 7 factor test that you have to provide all this evidence of. So those are all the forms. So you typically would not file an I-130 and an I-864 together if it's for an overseas case.
Rudy asks, is video evidence allowed in immigration court for an asylum application?
Oh, that's a good question. That is a good question. I think generally with USCIS, you can't ever submit video evidence. They won't take CDs. They won't take anything that has to be downloaded. But I think that if you had the right bit of evidence and you could convince the immigration judge that it's relevant and important for your case, and you have the ability to play it for them, the rules of evidence and things like that are pretty relaxed in immigration court. And I would think that if you can make a compelling argument, or if your lawyer can make a compelling argument, they might be willing to do it as long as it's not going to be overly time consuming. You would probably be responsible for whatever electronic hardware you would need to be able to play the video. But generally, you might be able to, if it depends on the judge, and it depends on what kind of case it is and why it's important. I'm going to add that to my list of questions, although I'm going to frame it for USCIS, because a lot of times people say, well, I have a wedding video, or I have an engagement party video, and they won't take that stuff, so you just have to do screenshots. All
Ready?
right. Yeah, I'm ready.
All right. Tanajdo asks, I am from Albania and I have a valid diversity visa. Due to COVID-19 travel ban, I am uncertain. Can I travel transit through a Schengen country? My country is not at the ban list. So
he already has the video?
He already has the visa.
The visa?
Yes.
He already has the visa? No, you wouldn't want to travel through a Schengen country area, because that would prevent you, I think, from getting a visa to the United States.
Juan says his mother is stuck here because of the current pandemic. He wants to file an extension, but he wants to know, how long can I request an extension for? Well,
that's a great question. So with the coronavirus, there are a lot of people who are stuck here in the United States, and I made a video about this about a month ago. We might be able to put it in the notes in the chat. But generally, if you are stuck in the United States and your visa is about to run out, you should definitely file an I-539, which is a extension request for change or extension of status. And even if it's not going to be granted, which it probably will not be granted, it's still a good thing to go ahead and apply for it. So you want to do everything you can to show that you complied with the law, because this might not come up like when you're leaving the United States or when you get back home. But where it could come up is if you need to get another visa, then you're going to have to explain to the officer down the road where or why you didn't leave on time. Now, everybody's going to understand that, because of the coronavirus, that people weren't able to leave on time. But there has not been a blanket extension given to everybody in the United States. So what I tell people is, you want to be doing everything you can to comply with the law, and you need to do everything you can to show that you tried to leave the United States on time. So first off would be a return trip ticket that was dated before your visa was expired. So in other words, so that you can show them whenever you need to that you had every intention of complying with the law and leaving on time, but it was because you couldn't get out of the United States or you couldn't get into your country that you weren't able to leave. And so what I would be doing is I would be calling airlines, and I would keep a notebook, and I would write down all my efforts to try to leave on time. You can't just say, oh, Corona, she can't leave, and then expect them to sort of bend over backwards to help you. You're going to need to prove it up. And when you're going to need to prove it up is later on, either when you try to enter the United States or when you try to get a new visa if your old visa has expired.
Nathaniel says the credit bureaus are not delivering the letter to show that someone doesn't have a credit report or score. How can I file for the I-944?
So again, you would want to document your efforts to show what you've done to try to follow the law. If you can prove it, either in writing from them that say we won't give you that, or if it's just an affidavit of your efforts to try to comply with it, I think that's all you can do. Just to do your best and just point out how it's impossible to comply.
Hedye says, I applied for a visa for my husband in 2015. At the time, she was a green card holder. He went for an interview to the U.S. Embassy in Iran in 2016. His case was put under administrative processing, and she hired a lawyer to file a mandamus, but the judge dismissed the case. They also filed a waiver 2 years ago. Now she is a naturalized citizen. What can she do?
That's interesting. That would probably be one we'd want to consult with. Now, with the Iranian ban, we can't overcome that every single time, but given the changes in circumstances, namely that you became a U.S. citizen and sort of other changes in the law, I think it might be beneficial to at least explore the possibility of filing a new lawsuit. I'd want to look at everything that got filed before. I'd want to see why it was denied. And if it was denied because they said 2 years ago that you hadn't waited long enough, well, now that might be a good leverage point that we would have if we were to sue them now.
Juan says that the IRS has posted on their website what you should do to return the stimulus check. If I'm adjusting my status to obtain a green card from an F1 visa, do you recommend that I return it to avoid issues with being a public charge?
So, one of Mackenzie's favorite video titles that I made this last year was why does everybody hate Jim? And we made that video because I had posted an earlier video when the affidavit or when the stimulus checks were announced that they were coming out. Okay, and so you should know, and if you watch my videos, you probably know that I don't trust USCIS, right? And I don't trust them to treat people fairly. I don't trust them to be an honest broker. I don't trust them to evaluate your case fairly through a fair lens. What I think they do is they look for reasons to screw immigrants. That's what I think. And so where I came from when those stimulus checks came out was the perspective of, boy, how could USCIS use this to screw people? Now, there's allegedly been some guidance that says that these cases, these checks, are not like payroll substitutions. And so therefore, they wouldn't count towards public charge. But I haven't seen it on any USCIS website. I haven't seen it on any USCIS emails. And until we see that, I believe that it would not be a good idea for an immigrant to take it, someone seeking to adjust status, and it's only them. It's not people who already have their 2-year green card. It's not people who are applying for a green card based on asylum. It's not for other types of cases. But if you are currently seeking adjustment of status, or if you think in the future you're going to seek adjustment of status for any reason other than asylum or as a refugee, I would not spend that money. What I would do is I would hold it in my bank account. At first I said, go ahead and return it. But now I've sort of backed off on that because so many people push back on me. What I'm now comfortable advising is, and again, this is just my best guess on how I think you should treat it. It's not actual legal analysis because we're in a gray area. But what I'm comfortable with is that you set that money aside, and if you go to your interview, and if they say, "Hey, did you get the stimulus check? Oh, you're a public charge," then you can say, "Ha ha ha, I kept that money and I'm ready to return it. I just wanted to wait until I had this interview to see if you guys were going to treat it that way, because I'd heard that it wasn't a public charge. But if you believe it is a public charge, I'm happy to return it, and I'll go down the hall or downstairs or over to the IRS and return it right now." So I don't think you have to formally send it back, but I think you have to be prepared to give it back if they, and this is probably overkill and probably me being a little bit conspiratorial and crazy. So if you did take that money, it's probably not going to be an issue, but I always have to operate from the worst case scenario and what's the worst thing that USCIS could try. And of course they could try to deny your green card saying that you're going to be a public charge. Now, if you have tons of other money or a job or whatever, if you have other ways to beat public charge, that's just going to be one factor. So that's sort of my long-winded answer of what I think about that.
All right. Dara says that she is a green card holder and she sponsored her spouse in India. He was scheduled for an interview, but due to COVID, it got canceled, and he got mail that they would reschedule it. Do you think the Trump ban would affect them, and what do you think will happen if they extend it after the 60 days?
Yes, that case would squarely be within the Trump ban. The ban definitely applies to the spouses of green card holders. Even if he had his interview, the question is whether he had his visa yet in hand. If you had your visa in hand, then it didn't count. And of course, I do think that it's going to be extended beyond the 60 days. So I think that unless there's a change during the election or unless something else happens, that is going to stay in place.
Okay. Irfan says, do you suggest filing for a writ of mandamus for a pending I-485 with a July 2018 receipt date? It's still within normal processing times for the Texas office.
Yes, that's ridiculous. I would file a writ of mandamus. That's 2 years. I don't care about their stupid processing times. They just keep pushing them back. If anybody ever tries to pull that in a case that I was thinking about this today. If the government ever tries to say, now one time I filed a case too early. I thought it was 18 months old. It was only 8 months old. So that was less than a year. But if anybody ever tries to say, hey, your dude or your dudette has not waited long enough, and oh, look at the processing times, I'm just going to get out the historical processing times and show how they just keep moving this shit backwards. Because in the old days, a year was definitely too long. And so now they're trying to make it arbitrarily longer just because they keep making their processing dates longer and longer. That's total BS.
Okay. Mayor Dad says, I'm an Iranian green card holder. My wife had a marriage case interview in Turkey last year before Christmas. The officer said he believes in our marriage, but at the same time said that they needed my wife's resume to do more investigation. Right now, there's confusion about my wife's status because in March 11th, it was showing as processing pending, and then on May 5th, it was updated to refused. What should I do?
Which country is this?
Turkey.
So tell me it again, Mackenzie.
Okay, so he is a green card holder from Iran. His wife had a marriage interview in Turkey last year before Christmas.
Yeah.
The officer said he believes in our marriage, but at the same time, they need my wife's resume to do more investigation.
Mm-hmm.
The case was updated on March 11th to show that it was processing pending 221G. And then the visa status in the SEAC was updated on May 5th, showing refused.
Mm-hmm. So again, I don't put any stock in what the electronic alerts say. I just have to go with, does my client have their visa? So here they don't. Number two, under the current legal scenario, are they entitled to their visa? I don't think that they are. So because of the Trump travel ban for the spouses of green card holders, I think that they're not coming anytime soon. We've tried to challenge that in court, but we were not successful. So I think that as things currently stand, the least of our concerns or issues are what it says online. I don't care about what it says online. What I care about is what's happening on the ground. And what it sounds like is the case is on hold, and they now they have to keep it on hold because of the Trump ban.
John says, I filed an appeal with the Connecticut federal court after my dad's N-648 was denied 3 times by USCIS. Recently, I received appearance from USCIS attorney asking referral to a magistrate judge, and today I received a letter from USCIS attorney asking for local 26F. What do I do now?
You hire an attorney because you can't pull this off. Sometimes people think that if they file a lawsuit without an attorney, if they download the form, that that USCIS is just going to roll over. But as is evidenced here, they're starting to screw with you. So as far as the magistrate, it depends which judge you have. If you have a Trump judge, I would take the magistrate. If you have a judge who was appointed by a semi-rational president, I would keep that judge. The other thing is the 20F. That's a list of witnesses, that factual witnesses, people who have information about the case. So that now you're getting to that point where when I first started doing mandamus lawsuits, I used to just do them for citizenship. And this Pakistani kid came to see me, and he had filed his own, and they started pulling tricks like this. And so that's when I started representing him. I think you're going to have a hard time because they're going to screw with you, and then they're going to file a motion to dismiss and then a motion for summary judgment. So I think that unless you have an attorney, they're not going to take your lawsuit very seriously.
Lalit says, I'm on an H-1B visa and I was furloughed by my employer for 2 months. Do you think my visa would be revoked? Is there a way to check if it has or not?
Yeah, I mean, you have to be continually working on an H-1B. So yeah, that's definitely in danger of being revoked. I mean, USCIS doesn't know that you've been laid off, but I would certainly think you'd want to be having conversations with HR and getting them to say in writing what the status of your H-1B is. There is a thing called benching that might be able to protect you, but you really need to be having an honest conversation with the employer and their immigration lawyer. And more than anything, you want them to say in writing what your current status is. And you want to sort of push back on them and say, hey, what's the deal? I'm sort of left out hanging here. What is your plan, or what is my status?
Samar says,
Just real quick, Mackenzie, just real quick.
Sure.
A lot of employers, especially these staffing companies, play really fast and loose with benching and with people off duty or furloughed or all those things. So you really want to be careful, because they might not have your best interest at heart, and they might be playing fast and loose with things that could affect you in a way that are never going to affect them, ways that are never going to affect them.
Samar says that his case is at the Visa Center, the National Visa Center stage. His wife makes enough to sponsor him, but they will have a baby in the last week of August. Do you think they'll need a joint sponsor at my interview because the wife only makes enough to prove a household of 2?
Yeah, you're going to need a co-sponsor. You never want to cut it too close. You're going to want to have 3 good years of earning history, and you never want to cut it too close with a co-sponsor. I mean, without a co-sponsor. You never just want to rely on one person's income. If it's right on the border, or like you said, if you're having a kid and it's going to change the calculation, you want to make sure that you want to clear it by a mile. You don't want to clear it by an inch. You want it to be very, very clear that you're eligible. Otherwise, it's going to cost you 3 months' time.
Brian asks, for a foreign national in removal proceedings with a pending asylum case and an approved I-130 from a marriage to a U.S. citizen, is the best option to get LPR status to request voluntary departure. Case cannot be administratively closed, so the I-601, 601A has not been submitted.
Before you leave, you talk to a lawyer. So this is not the kind of advice I can give out on a call like this. We need to sit down and look at documents. We need to figure out if the I-130 has been approved. We have to figure out next steps. We have to figure out what the judge is willing to do and what we need to do to try and get permission to file the waiver. So that's something that I'm not going to be able to answer on this particular call.
Clarice says she's a refugee derived from an asylee, which was her mom. Her mom became a citizen when she was 16 years old, but did not file for her. I currently have my I-94 and a foreign passport. Am I automatically a citizen as well since I was under 18 when she became a citizen, or do I have to apply for myself?
So that's a really complicated area of the law that I just looked at the other day. Basically, you're going to have there's an inquiry that's going to go to how long mom stayed in the United States, what the person asking the question, who they were residing with, who had custody over them, and you have to look at the whole timeline. So again, I'm sorry I can't do that on this call, but basically there's a chart that sort of sets forth, you know, what the elements are to establish derivative citizenship, which is what she's talking about. So basically, for those of you who don't know, some people, you can become a citizen by operation of law when your parent naturalizes. And it's not just that you're a kid under 16 when they naturalize. There's these other factors like, have they lived in the United States for enough time? Are they in the custody? How do they enter the United States? If you entered as a refugee, that might be a little bit harder. I'm thinking that you probably have to file your own N-400, but like I said, we'd want to do all that because you don't want to file the wrong form and lose that filing fee and have to start all over.
Absal says, my friend has a valid M visa who abandoned her asylum seeking without filing for advance parole last year. She went back to her home country after the threat from the Taliban did not exist any further. Do you think she'll be allowed back to visit the U.S.?
No. No, they're just going to think she's coming back to apply for asylum. I think it's very unlikely she's going to come back on a non-immigrant visa.
Narciss says, my wife won the DS-260 family lottery, but I, the husband, is in the U.S. already. What do I need to do? I have filed for asylum and my final hearing is coming up.
That is an interesting question. Boy, you guys got some good ones today. All right, so let's unpack that. So I'm in the United States. I am an asylum seeker. I am married to a foreign national who won the diversity visa lottery. The diversity visa is on hold. So the question is whether you have any kind of independent status, and apparently you don't, otherwise you wouldn't be in immigration court. So this person is in immigration court. So one thing to keep in mind for everybody out there is that when you are in the United States and you want to adjust status, generally you have to be in status at the time that you want to adjust status. What do I mean by that? Well, in order to adjust status, you have to be in some kind of valid status. So, and the only exception is if you marry a U.S. citizen. So putting that to the side, if you're in the United States and you win the diversity visa, but you've been out of status for 30 years or a year, it's as if you were never selected in the lottery. You can't adjust because it's only by marrying a U.S. citizen or being an immediate relative of a U.S. citizen that you have that ability to have being out of status forgiven for purposes of adjustment of status. So let's make it a little bit simpler. Let's say that this guy who's in immigration court won the diversity visa. If he's in immigration court, he's out of status. He's allowed to stay. He's authorized to stay, but he's not in valid immigration status for purposes of adjustment. Okay? So overall, my answer is it's probably not going to work. So the weird thing with asylum is that you can, in theory, adjust if you're in valid status and your case is still at the asylum office. But if you're at the immigration court, the cases say that you can't adjust based on that, of course, unless you marry a U.S. citizen. So I think the answer to this question is probably that they're not going to be able to adjust status based on their spouse winning the diversity visa. And of course, they didn't win it, their spouse did. So I think that's probably the answer. But I also think that when you're talking about winning the lottery and a chance for a green card, that it's probably worthwhile hiring an attorney, me or anybody else, to do that research. And it's not something that's so important that you don't want to leave it to you. If you are in asylum court and you have an immigration lawyer, ask them, but you really want to nail down whether this is anything possible that could help you. It's not something that's worth writing off just because Jim says so on this info, on this Ask Me Anything.
Okay. Rafi says, I received an RFE and they asked me to submit evidence supporting intent to marry was bona fide. I'm interested to have your law firm office take over this case and process it. Will you please explain to me what this RFE means?
Yeah. I got an RFE that asked for submit evidence supporting intent to marry was bona fide. Okay. So, yeah. So it's interesting. They are pushing back on marriage cases like they never have before. We are seeing more requests for evidence, more denials, more inquiry into past marriages. We're seeing all kinds of stuff that they never did before. Now, of course, USCIS is claiming that they're broke, and it's because they're doing all this stupid stuff. But basically, what the Rafi's RFE is asking for, they're asking him to submit evidence that the intent to marry was bona fide. Bona fide means in good faith. So in other words, you have not convinced them, Rafi, that your marriage is valid for purposes of sponsoring her for an I-130. Now, this is interesting because this suggests to me that your I-130 is overseas. Rafi, can you leave me a note down below real quick? Is this a case where your spouse is in the United States or outside the United States? If it's inside the United States, that's sort of an ordinary occurrence, getting an RFE that says basically you haven't submitted enough marital evidence. But if it's an overseas case, that's unusual. We haven't seen that many times where USCIS has sent a request for evidence asking for proof that the marriage was valid, that the marriage was entered into in good faith. That's very unusual. So it suggests to me, if it is an overseas case, and Rafi hasn't responded in the chat, but it suggests to me that you probably didn't submit enough evidence. Either way, you're going to have to submit more evidence, either one. So in our office, all we do is immigration, obviously, and our bread and butter are spouse and fiance cases. So I will, just real quick as a bonus for everybody who's here on the call, I'm going to go ahead and I'll put in the chat. I think I can I put a document in the chat, Mackenzie?
I don't think so, but if you go to handouts, you could probably upload one.
All right, cool. Rafi, this is for you. Let me see if I can just real quick put it here. Drop it like it's hot. Here it comes, people. It's uploading now. Drop it like it's hot. It's 50% uploaded. This is our evidence of marriage checklist. Now, I'm happy to give this out. I tell people all the time in our YouTube videos that we'll share this. In and of itself, oh, look at everybody's clicking on it. Everybody's clicking on it. It's going like hotcakes. We're at 50% of the people, 11 clicks, 13 clicks. Everybody wants that thing. Come on, people. I'll give you that anytime you want. Just email me. You don't have to come to the webinar just to get that. 70% of our audience downloaded the evidence of marriage list. And I'm happy to give it away, just as I'm happy to give away everything that we do, because there's a big difference between having the list of what they need and packaging it together. So hopefully Rafi's still with us and is going to avail himself or herself of the evidence of marriage list. That's a good start, but there's no substitute to having us do it for you, because I work with my wife and Mackenzie works with my wife. My wife is a badass, hard-ass lawyer, and she'll stand on your head until you give her every document you can possibly get. We have a case like this now where our paralegal and our younger attorney were just listening to the client say how hard it was to get everything. And this went on for about a week, and the client wouldn't get us this marital evidence. So Amani gets on the phone with them. I should do a video on this. Amani gets on the phone with him, and the first thing she says to him is, "Do you like living in America? Do you like being here?" "Yeah, oh yeah, I really like it a lot." "Well, then you got to stop telling people that it's impossible for you to get these documents." And then she just went off on him. She told a story. I hadn't heard this story. I didn't know anything about this. She told a story where a client of hers got an RFE just like the one Rafi got. I think it was a 751, not an I-130, but the same thing. And this lady didn't have squat. And this lady had some kind of physical disability. I think she was in a walker or a wheelchair. She wasn't old or anything. I think she just had some medical conditions. And Imani told this guy who was telling the paralegal and the lawyers that he couldn't get anything. Yeah, Rafi, I'll hit you. Imani told him that you need this lady. She drove to her old apartment complex in Kansas, and she went up the stairs and she knocked on all the doors until she found some tenants who remembered her and her husband and got them to write affidavits. That's the level of detail that working with a lawyer will do, and that's the level of detail that you need in order to win, because that's what we're talking about. We're talking about winning. We're talking about punching them in the mouth and winning. So that's what you have to do when you get an I-130. Okay, so Rafi says that the spouse doesn't live in the United States. That's fine. Now, that bothers me because that means we're now getting RFEs on I-130 aways, which is what we call those. I-130s here or I-130s away. I-130 away, it's very unusual that you would get a request for evidence on that. So that means they've turned up the level of their evilness even higher. This one goes to 11, right? And so, and the reason I say that is because usually when someone marries someone from overseas, they come back and they file right away. And it's not like they're in Philadelphia living together in an apartment with a joint car, health insurance, car insurance, all that stuff. It's much harder when the foreign national's overseas and the marriage is new to prove the relationship. So the way that you do that is, and Rafi, make sure you download, if you look at the handouts, that you download the evidence of marriage list, that it's much harder to document that. So then you're talking about proof that I go over there, proof that we communicate. Here are our texts. Here's our chat records. Here's pictures of when I went to visit. Here's my receipts for money that I send overseas. If you're getting an RFE on an I-130 away, your case is in trouble and they want to deny it. So you've got a lot of work to do. All right.
All right.
Got a little fired up there, didn't I?
I know. And Kita says, I'm on an F1 currently working full time. I got an email from embassy saying that my visa has been revoked. I'm guessing this can be because of a misdemeanor arrest I had when I was a student here. Please guide me on what can I do.
Well, okay, so we do have a YouTube video on this topic, but basically, when a visa, if you're here on an F1 and your visa gets revoked, in theory, you could stay here in the United States until you become a U.S. citizen. How would that work? Well, that would mean that you don't leave the United States. So revoking your visa doesn't mean that you have to leave. Now, I had a case last year where this Iranian kid got his F1 visa revoked, and the FBI came knocking on his door the next day. That's unusual, but he was Iranian, and the United States government treats Iranian students terribly. But anyway, if your visa is revoked, that just means you're not going to be able to enter the United States again without going to an embassy and getting a new visa. So you could stay here if you're in valid immigration status and don't violate the terms of your status with a revoked visa. So it's not that a big a deal. It's a big deal, especially if you were planning to go home for the holidays or wanted to go to Canada or Mexico or something. But if you're comfortable staying here, as long as you keep your I-20 updated and don't violate the terms of your status, you could, in theory, go from your F1 to an OPT, to an H-1B, to a green card, to citizenship, all with that revoked visa. Now, I don't know anybody who's ever done that, but in theory, it would work. Now, one thing that you said that sort of concerned me was that you said you're on an F1 and you're working full-time. I'm assuming that you're on OPT and probably coming to the end of your studies. So you want to be careful with working full-time on an F1. So if you're on CPT, that means that you might not be in status, or you're on CPT. Full-time CPT is real problematic. I really try to steer people away from there. So yeah, you're not going to be able to get you're not going to be able to get an H-1B visa stamped. Most likely, they're probably not going to let you back in. They're not giving regular people without a prior revoked visa their H-1B visa stamps like they're supposed to. They would definitely mess with you and keep you from being able to get that stamp, I would imagine. Yeah, she's on OPT. So in other words, Ankita, I think that means you're stuck here. You're stuck here until you leave because there's no guarantee you're going to get another visa to come back. And I don't remember what was the reason it was revoked? Was it a charge of some kind? Misdemeanor arrest.
Yeah, she says she thinks it's from her misdemeanor arrest.
Yeah, so we see that. No, you can't do anything. Ankita, you can't do anything from here. You can't do anything from here to challenge that. There's no way to challenge it. The State Department has complete discretion. So, I mean, the way that you challenge it or review it is you prove that you, I suspect this might be a shoplifting charge. It's DUI and shoplifting are the two ones that we've been seeing a lot of revocations for. You could try to go after that conviction and get it thrown out. And then when you go to get your visa stamp, you're completely at the mercy of the embassy. There's nothing I can do for you here. There's nothing your employer can do. And so the dirty trick is they just don't give you the visa and you don't come back. All right. Well, we're getting some more questions. Oh, is that John? Is he the one doing the case on his own? John, you can't win without a lawyer. They're going to screw you. I saw your question. How do I win without a lawyer? You're not going to. I don't think. The purpose, I mean, most lawsuits, just so everybody knows, most lawsuits isn't for the purpose of having a trial or for litigating the case with the U.S. attorney. You file the lawsuit to get USCIS to John, what jurisdiction is your case pending in? Leave us a note. Yeah, Ankita, that's good. Oh, Connecticut. John, send me an email. Maybe there's something we can do. I'm not licensed in Connecticut, obviously, but I have some friends there. Maybe we can rattle their cage a little bit. If there's a U.S. attorney, I could tell them, just send me an email, John, and we'll see if we can help you. Because if it's your dad's N648 and if it's a BS denial, then let's screw with them. All right.
Rafi wants to know, will you be able to process the spouse case with the RFE? He said it was an overseas visa.
Yeah, Rafi, we'll help. Everyone's going to get all the contact information at the end, right? Do we have a slide for that, Mackenzie, or do we?
No, but I can put it in the chat. Okay,
when we're done, we'll put all and everyone's going to get emails from us. You'll be amazed at how many emails you get from us, and you'll be like, Jim, send me an email. So you'll be able to get a hold of us. Yeah, and we'll be happy to help you, Rafi. Just email us, and we'll follow up tomorrow.
Nathaniel says he's not able to request his high school transcripts to prove that he speaks English and completed an English course, even though English is his native language, due to COVID-19, where all the offices are closed. So all the offices are closed because of COVID-19. However, I have my college degree. Will that suffice for the I-944?
Yeah, I would think so. I mean, what I would do is I would, again, document my efforts to obtain my high school diploma, show that I went to college. Maybe the college can send a letter that says, hey, we wouldn't have let him in if he hadn't finished high school. You know, try to be creative if you can, but even at the worst case scenario, just sign an affidavit. I graduated from this high school on such and such a day, and that's why I was able to go to college, so that give them some evidence of it.
Janelle has a similar question. He says, not able to request my tax transcripts by mail due to COVID-19. What else can I submit?
Usually the tax transcripts you can get online, can't you? I think that we usually have our clients just log onto the IRS website and download it that way.
Her fan says, is it possible for USCIS to have a legitimate reason to prolong the case after a writ of mandamus is filed?
Yes, they can. Do you know what it is? It's called coronavirus. That's a legitimate reason. So just so everybody knows, we've been giving out extensions sort of like candy. So, you know, you got to be reasonable when you file these lawsuits. But generally, depending on how long your case has been pending and how long you've been waiting, they don't usually come up with too many excuses. Usually they just move the case along and off it goes. I mean, every now and then they'll file a motion to dismiss, which is just more of an extension, but they don't ever have to really give a reason. They can just file a motion to dismiss or to transfer cases just to slow things down.
Dara asks, how many days do you think Trump will extend the immigration ban after the 60 days? He mentioned something that he will decide on day 50 of the proclamation.
Yeah, so the proclamation was March 22nd, so 60 days from that would be June 22nd, and then 10 days earlier than that would be like in 4 days. I suspect he's going to extend it until the election's over. I think that 60-day stuff's just BS to give them cover and give them arguments to make in court.
Here's a new one. Raheem says, I filed an I-485 marriage-based adjustment of status. After several months, the I-485 and I-65 was denied due to evidence wasn't forward. After receiving it, I filed the I-290B for reopening and sent the missing documents. After 2 weeks, I received an RFE for an I-130. I sent the documents and asked, and now it's been 2 months since they received it. How long will it take them to hear back? And what's the next step?
Yeah, so 290Bs are a waste of time. So I would not appeal a denied 45. They're going to stand by their denial. That's just a waste of time. What you should have done is strengthen the I-130 and file a new I-45, which is what I would still recommend doing. So I would do everything I can to try to get the I-130 approved, and then once it is, file a new 45, or just go ahead and file the 45, a new one. Getting a denial is sort of a big deal, sort of surprising, and it's probably because you didn't give them all the right evidence. So you're probably going to need help, especially now that you already have a one denial. 290B is a waste of time and money.
And Kita asks, will marrying someone with a green card or permanent resident can help me with my visa revoked situation?
Yes, and Kita, you should be able to adjust status. The shoplifting charge or the criminal charge that you have wouldn't make you inadmissible. So because the visas are current for the spouses of green card holders, you could do it all here in the United States. You could get married as long as it's a valid marriage and not for purposes of immigration. But if it's a real marriage, someone that you love, and that's why you're getting married, you would be able to adjust status with a revoked visa.
Aslam asks, can I get a green card on the basis of my baby, which was born in the U.S. and is a U.S. citizen?
When that baby turns 21, yep.
Okay. Samar, we answered that question. Hedye says, Jim, also, does it help if I go back to Iran and live with him meanwhile? Do I need to stay here and work since I'm his sponsor? And since I filed a mandamus, is it okay to file it again?
Again, with an Iranian case, they're always going to fight harder on those. It's hard for me to say, but I think if it's been 2 years since and you became a U.S. citizen, I would encourage you to at least think about suing them again. Yeah, there's not a rule that says you can't. Looks like Abdul Jamil is trying to get us to answer his question. Let's see if we can find it.
I found it. I'm not sure exactly what he means. He says, good afternoon. I filed lawsuit. Is pregnancy helping in this type of case? Is unemployment count public charge?
Yeah, Abdul, that's a hard one to figure out, to interpret. Maybe you can sort of try to restate it. Yeah, Rafi, we got your email. Don't worry about it, babe. We'll get to you.
Afzal says, is my guest in Pakistan barred for life for the I-130? This is the one who has the valid M visa and abandoned her asylum.
It's not a per se bar. I just think it's unlikely that the embassy's ever going to give them a visa. An I-130 they probably would, but a visit visa, no way. And Hidayah, we can't file a lawsuit right now if it just got dismissed in February. I thought the lawsuit was 2 years ago. All right, I got about time for probably 1 or 2 more questions, Mackenzie, if we got any more.
All right. Hopefully Abdul was going to resend his email, but it doesn't look like it. He will. But I think that's pretty much all of them.
Okay, so here is our website. Here is our email address. Here is our phone number. When they get the video replay, does it have the chat or no?
I don't think so.
Okay. All right. Okay. No, I saw the San Diego field office is not open yet. Inshallah, soon, probably a year or so. They are saying that the fees are going to go up 10% right now, real quick. They're broke allegedly, so fees are supposed to be going up. Abdul says his question wasn't answered. Maybe you can find it real quick, Mackenzie. I'm gonna get a link to our YouTube channel.
Is this the same Abdul that we just talked about?
I don't know. It was green. He was a green Abdul. I don't know.
I don't see any from green.
Yeah, Abdul, try to put the question again if you can real quick before we sign off. Our YouTube channel, we're trying to hit 20,000, so if you haven't subscribed yet, please go ahead. And then I'll do immigrant home as well.
Real quick, Lalit asks, am I considered terminated on my H-1B unless the employer offers me a one-way ticket?
Employers are supposed to give you a one-way ticket, but if they don't, that doesn't mean you're not terminated. They're supposed to, but their failure to comply with the law doesn't change your immigration status. Asylum wants to know when the next session will take place. Probably about a month from now, right, Mackenzie? Because in 2 weeks we'll do 2 weeks we'll do the delay lawsuit. Yeah, and then we'll do this one in about a month.
Mm-hmm.
All right, everybody, we're gonna sign off. Peace to all of you. Stay safe, stay healthy, enjoy the summer, the warm weather, and we'll see you next time. Thanks, everybody. Thanks, Mackenzie. I'll see you tomorrow.
Thanks. Bye.
Okay, bye.